It's a great pleasure to have the opportunity to speak to you about my current project, which is a book, as you've just heard, about lawsuits involving writers as litigants and literary texts as evidence. I contend that this is an arena in which we can learn something about literature from law and something about law from literature, and also one in which tensions between the two realms can be productively explored. In the book, I cover 8 cases involving 10 writers that span nearly 150 years, multiple jurisdictions, and multiple fields of law. Today, I'm going to provide you with snapshots of just 3 of those cases, lawsuits launched by Edgar Allan Poe, Lucy Maud Montgomery, and Theodore Dreiser. These are not writers that one often thinks of together. They represent different times, different genres, different aesthetics, different politics. But the stories of their legal battles highlight one of the common themes that's emerged from my study of writers' lawsuits. All 3 of them turn to law to protect, to preserve, or to restore their literary reputations, albeit with varying results. Making English the subject of one of his portraits of the New York literati. These were a series of satirical sketches that Poe published in Godey's Lady's book, and they were mostly about well-known figures in the literary establishment of the day. Poe had made a name for himself as a bold and uncompromising literary critic, but this was not his finest hour in that respect. He was already very much an outsider to the literary establishment, and in typical self-destructive fashion, he put the final nail in the coffin with these pieces, which were mostly gossipy and personal rather than aesthetic judgments. In the June 1846 installment, Poe accused English of plagiarism, criticized his grasp of grammar, and wrote of him, "No spectacle can be more pitiable than that of a man without the commonest school education, busying himself in attempts to instruct mankind on topics of polite literature." English issued a lengthy reply, published in the New York Mirror, in which he accused Poe of borrowing money under false pretenses, of forgery, habitual drunkenness, insanity, and various instances of ungentlemanly conduct. You'd think ungentlemanly tacked onto the rest of that would be, but anyway. To these personal failings, English added literary crimes, writing, "Poe is not alone thoroughly unprincipled, base, and depraved, but silly, vain, and ignorant. Not alone an assassin in morals, but a quack in literature. His frequent quotations from languages of which he is entirely ignorant, and his consequent blunders expose him to ridicule, while his cool plagiarisms from known or forgotten writers excite the public amazement." It was this reply from English that prompted Poe to launch a libel suit. In the posturing that led up to it, English basically told Poe to bring it on. Let him institute a suit if he dare, and I pledge myself to make my charges good by the most ample and satisfactory evidence. But when the suit finally commenced, English was conspicuously absent, having decamped for Washington, D.C., reportedly fearing the consequences for himself if Poe prevailed. Somewhat bewilderingly, though, Poe hadn't actually sued English. He hadn't named him in the suit. He'd taken action exclusively against Hiram Fuller and the New York Mirror, editor and publisher of English's alleged libel. However, as the defendants asserted truth by way of defense, English's testimony was crucial, and his absence caused the trial to be delayed from the originally scheduled date in September 1846 until February 1847, when a commission was created to obtain English's deposition in Washington. This was done, and unfortunately for the defendants, English was not able to provide any evidence that Poe had borrowed money from him under false pretenses, or indeed that he'd borrowed any money from him at all. He was also unable to back up his accusation of forgery. So the defendants changed tack and argued that Poe's character was sufficiently disreputable that he had no reputation to protect. But although Poe's own character witness conceded that he was occasionally addicted to intoxicants, the jury ultimately found in his favor, awarding him $225.06 in damages and $101.42 in costs. $225 is about $5,000 in contemporary money, so not a paltry sum. And Poe trumpeted this victory as full vindication. Ultimately, though, it seems that Poe's lawsuit did more damage to his reputation rather than clearing his name. For libel suits are not generally viewed favorably in the literary world. As noted, Poe was already a marginal figure, and he'd further alienated many powerful people with his New York literati sketches. His libel suit, and in particular his decision to sue the editor and the publisher rather than the writer of the offending words, were another strike against him. And the suit opened the door to much wider discussion and dissemination of rumors about Poe's drinking habits and his insanity than had previously occurred. So with all of this swirling around him, an ill and as ever broke Poe had a great deal of difficulty getting his work placed anywhere. Nobody would publish him, and this desperate state of affairs persisted until his early death 2 years later. One of the most vicious attacks against Poe occurred in the guise of fiction and was penned by none other than Thomas Dunn English, albeit under cover of anonymity this time. It was a novel titled 1844, or The Power of the SF, first published in serial form in, you might have guessed, the New York Mirror, also not fans of Poe. Several segments of this novel featured a character named Marmaduke Hammerhead, a writer exactly matching Poe's physical description, who was identified as the author of a popular poem titled The Black Crow. You get the reference. Hammerhead appeared in a number of episodes, completely extraneous to the plot, lying drunk in the gutter, borrowing money from everyone, spouting nonsensical literary criticism, and finally installed as an inmate in Utica Lunatic Asylum. Yeah. Poe also got his revenge in fiction, however, in a short story titled The Cask of Amontillado. This was a more subtle vehicle than English's piece, for the characters in it are not such obvious representations of the players in the lawsuit, but it's as chilling a story of revenge as you'll find anywhere, with the narrator burying his enemy alive by bricking him up in his wine cellar. And perhaps it counts as the best revenge, because in the long run, Poe's literary reputation far outstretched English's. Have any of you ever heard of English until now? No, there you go. And his novel is known now, if it's known at all, only in connection of Poe, while Poe's story has become a classic. On to my second subject, then. L.M. Montgomery and her lengthy legal battle against Lewis Page. Montgomery's first novel, Anne of Green Gables, was published by L.C. Page and Company, a Boston firm named for and headed by Lewis Page in 1908. The contract was, in Montgomery's words, a hard one, even for a beginner. And because of a binding clause contained within it, she published 6 more books with Page on the same terms. When the contract expired in 1916 and Page proved unwilling to negotiate more favorable terms, despite Montgomery having by then attained bestseller status, she switched publishers. This split with Page ultimately triggered a slew of lawsuits that spanned the better part of a decade. Montgomery initiated legal action against Page, first over royalties that he withheld, and later over his publication of an unauthorized volume of short stories, while Page retaliated with a pair of defamation suits. I'm going to focus on the suit about the short story collection, but I need to provide you with a bit of background. In the aftermath of the suit over the royalties, which Montgomery won in a Boston courtroom in 1919, Page offered to buy out all rights in the books that she had published with him, the six books. This idea appealed to Montgomery, as she didn't want to have to deal with them anymore. She realized that trying to get royalties out of him on a continuing basis would just be a struggle. She calculated that $18,000 would be a sufficient amount of money to offset the royalties that she would be losing by such a deal. So when Page finally came up to that amount, she was prepared to sign on. An agreement to effect the purchase had to be negotiated, and Page proposed that it include the right to publish one further book, comprised of 16 short stories that Montgomery had submitted in 1912 for potential inclusion in a short story collection titled Chronicles of Avonlea, but that had not made the final cut. Montgomery agreed. This may seem a baffling decision, given that her primary motivation for selling out her rights to him was to ensure that she wouldn't have to have any further dealings with them, but she had her reasons. She was aware that a number of those stories didn't have copyright protection in the US, and that Page could go ahead and publish them without her consent. She had deliberately worked Anne references into them in 1912 to forge a connection to her earlier work, and she feared that having them appear in that form under Page's imprint now would violate her contract with her new US publisher, Frederick Stokes. Further, she'd since reused passages from several of the stories in other published work, and was afraid that having them appear now as is with those repetitions would make her look ridiculous. Finally, she was sure that Page would time the release of an unauthorized volume to directly compete with her next novel, due out the following year from Stokes. So she thought at this stage that it was better to give her consent and to thereby attain a measure of control over the content, presentation, and timing of the book. And indeed, she was able to argue successfully for the inclusion in the new agreement of terms prohibiting Page from including mentions of Anne in the book and from releasing the book at the same time as her forthcoming Anne novel from Stokes. Montgomery revised the stories in accordance with their agreement, sent them to Page, and thought that that would be the end of it. Alas, no. Shortly thereafter, Page found copies of the 1912 versions containing Anne references and informed her that those would be used in the book instead. She told him that she regarded this as a violation of their agreement, but her objections were to no avail. Further Chronicles of Avonlea came out in April 1920, containing the 1912 versions instead of the 1919 revisions. On receiving a copy of the book, she wrote, "It is got up to resemble the Anne books in every way and is an evident attempt to palm it off on the public as an Anne book. They have put a red-haired girl on the cover, as appears on all the Anne books, another evasion of the terms of our agreement. But everything is so skillfully done that it will be very hard, impossible, I fear, to bring it home to them." Nevertheless, she was willing to try. She didn't relish the prospect of another round of litigation, but felt that she must stand up for herself. She wrote, "I fear my chance of winning is not good, considering the unscrupulous character of the men I have to deal with. They will swear to any lie they safely can. I will likely lose and throw away a lot of money, but there's something in me that will not remain inactive under injustice and trickery, and to satisfy that, I am driven to this." The trial began on May 20th, 1920, and was to have lasted only 2 or 3 days. Ultimately, it stretched out into 6 weeks, nearly half of which Montgomery spent on the stand. This was an exhausting and stressful experience, though Montgomery did manage on occasion to find humor in the situation. "Those 3 grave lawyers and myself wrangled all day over the question of the exact color of Anne's hair and the definition of Titian red. Ye gods, it was funny. The big table was snowed under with literature and prints to prove or disprove.
Years ago, when I sat down in that old kitchen in Cavendish and dowered Anne with red hair, I did not dream that a day would come when it would be argued over like this in a courtroom. The raison d'etre of all this is the red-headed girl's picture on the book cover. Now, to give you an opportunity to make up your own mind whether you think Page was trying to pass off Chronicles as a Anne book, let me give you a basis for comparison. There's Anne of Green Gables, 1908, Anne of Avonlea, 1909, and Anne of the Island, 1915. In April 1923, the court found for Montgomery, granting an injunction against further sale of further Chronicles of Avonlea and awarding her all the profits from the sales that had already occurred. 2 years later, the Supreme Judicial Court of Massachusetts upheld that decision on appeal, finding that while the agreement between Page and Montgomery clearly gave him the right to publish the revised stories Montgomery had submitted to him in 1919, it didn't give him the right to publish the 1912 versions. Otherwise, the judge opined, the various other stipulations in the contract about not mentioning Anne and so on would have been nonsensical. Page didn't appeal this decision any further, but he took the new tack of claiming that further Chronicles had generated no profits, so 0 damages. She knew this claim to be false, but had to take him to court yet again for an accounting to determine the profits to which the court's decision determined she was entitled. It wasn't until 1928 that she finally obtained the accounting she'd requested, and it determined that the book had indeed generated profits. The court's final decree dictated that Montgomery receive an injunction against further sales of the book and a damage award totaling a little more than $18,000, about $240,000 in 2012 dollars. Montgomery calculated that the financial cost of the years of litigation totaled at least $14,000. Subtracting that from her $18,000, she was only $4,000 ahead after all of that stress and worry and testimony and so on. But of course, money had never been her prime motivation. So what did drive her to go to court? First and foremost, I think, she felt compelled to stand up for the integrity of her work. She wouldn't even have considered publishing most of the stories that were contained in further Chronicles in book form had Page not pressured her to do so. And the quality of the 1912 versions was significantly lower than that of the 1919 revisions. She considered them poor stuff, which reflected badly on her. She wrote to her friend Ephraim Weber of the book, "If you happen to see it, do not read it. It would leave you with no respect for my literary powers. Except for 2 or 3, the stories were very poor indeed." And to another friend, George Boyd McMillan, who expressed surprise upon stumbling upon this book of hers that he hadn't known existed, she described it as that illegitimate offspring which I have never acknowledged, that sole stain on my otherwise spotless career. She wanted an injunction so that she could usher that illegitimate offspring back into the shadows. Can we count her eventual success in attaining one as a legal victory for literary reputation? On the face of it, yes, but in actuality, not really, since the print run of Page's unauthorized volume had sold out long before the litigation concluded. And in the long run, her reputation wasn't going to stand or fall on the 1912 versus the 1919 versions of those stories. Her best work was never her short stories, but her novels. And even those, despite their vast and ongoing popularity, never got their critical due during her lifetime, or indeed, for a very long time thereafter, having been dismissed by the keepers of the Canadian canon as treacly girls' stories. In a roundabout way, though, I think that the lawsuit did help her literary reputation. For the serious critical attention that her work has received only in recent decades came about largely because of revelation of details about her life. Details like this legal episode, revealed when her journals were first published beginning in 1985. The fact that she was so very different from the popular perception of her, a simple, sunshiny author of children's stories, led many to return to her work and to reassess it, and to see that it too had more depth and complexity than it had been given credit for. The legal battle against Page shows her to have been a brave, somewhat unconventional woman who took pride in her work and was prepared to go to court at some cost to defend its integrity. And it also demonstrated that she was willing to stand up for other writers as well as herself. On that point, I'll give her the last word. On the eve of the trial, she wrote in her journal, "The Page Co. need a lesson. They have traded for years on the average woman's fear of litigation and the fact that very few authors can afford to go to law with them, especially when they can't expect to get money out of the result. They have done the most outrageous things to poor authors who can't afford to seek redress. I want to teach them a lesson." And so she did. On to my third and final subject, Theodore Dreiser and his 1931 suit against Paramount Pictures. An American Tragedy, Dreiser's sixth and most successful novel, was published in 2 volumes in 1925. Despite its heft, 840 pages, and the grimness of its subject matter, a pregnancy out of wedlock, a suspicious death, a murder trial, given its bestseller status, the movie people soon came calling. Dreiser sold the silent film rights to Paramount in 1926 for the then staggering sum of $90,000. But given concerns over the content and the likelihood of censorship, the proposed silent film version was never made. With the passage of time and technological advancement, the project was revisited in 1930, and in an agreement dated January 2nd, 1931, for an additional $55,000, Dreiser sold the talking picture rights to Paramount as well, and the filmmaking commenced. Dreiser was skeptical about the film industry and sought close involvement in the making of the picture and final approval over the script to ensure its faithfulness to the message of the book. Paramount, unsurprisingly, wasn't willing to give him that kind of control. In the end, all that he was able to wrest out of them in the final contract was a clause, Clause 10, dictating that they would submit the proposed script to him before the film was made for his comments, advice, suggestions, or criticisms. And they would afford him an opportunity to discuss the script with the scriptwriter, and they would, and I'm quoting from Clause 10 here, use their best endeavors to accept his advice, suggestions, and criticism. So really, nothing. Nearly everything that happened thereafter was in dispute in the eventual lawsuit. Paramount claimed that they had difficulty finding Dreiser to consult with him about the script. Dreiser claims that they made no sincere effort to do so. In any event, when he finally did have a look at the script, Dreiser was so appalled by it that he refused to discuss it with the scriptwriter, arguing that it couldn't be saved. When he realized that they were going to go ahead and make the film anyways without his approval, he became involved once again, traveling to Hollywood, watching rushes as the picture was filmed, and offering criticism and suggestions. Dreiser claimed that Paramount didn't seriously entertain any of his suggestions, while they claimed that, in fact, they'd incorporated all of his suggestions, at least the ones that were practical and that wouldn't run afoul of the censor board. Ultimately, when Dreiser viewed the finished product in June 1931, he wasn't happy. He arranged a viewing of it by a group of his friends, or, as he termed it, a jury of critics and authorities, asking them to respond to the question, whether or not, in your opinion, the picture carries out the ideology of the book as to hold me free from any personal or artistic harm before the world. When their resounding response echoed his own opinion that the picture did not do justice to the book and would thereby damage his literary reputation, he sought an injunction to prevent Paramount from releasing the film. He wasn't so much concerned with the film's fidelity to the letter of the novel as to its spirit. The book, he said, was to stand as an indictment of society, religion, and the justice system, not as an indictment of the main character, Clyde, as an individual. Clyde, the putative murderer, was to be portrayed sympathetically as a victim of tragedy who meets an inevitable end, not as the villain of the piece. Dreiser's narrowest legal argument was that Paramount had violated the aforementioned Clause 10 in the contract, affording him an opportunity to consult about the script and to make suggestions. But he made a much broader argument as well, which he elaborated as follows. I have a literary character to maintain, and I contend that I have a mental equity in my product and the character of my product. Even though they buy the right of reproduction, they don't buy the right to change it into anything they please. The word reproduction means what it says. They can't make a piece of work that's inimical to my standards and picture me as writing something I never in the world would have written. Dreiser made no headway in court with either of these arguments. On the narrower issue of whether Clause 10 of the agreement had been complied with, the judge accepted the defendant's evidence over Dreiser's. On the broader question, the judge appeared to conclude that the film did do justice to the book, stating, "Whether the picture substantially presents the book or not depends on one's point of view," and citing various of the defendant's experts who asserted that it did. But he also seemed to indicate that the defendants were not actually obligated to produce a film that was true to the book, in that they could, if they wished, alter the story according to their perception of what message a film audience would like to hear, stating, "In the preparation of the picture, the producer must give consideration to the fact that the great majority of people composing the audience before which the picture will be presented will be more interested in seeing justice prevail over wrongdoing than that the inevitability of Clyde's end clearly appear." If the defendants had no obligation to produce a film that was true to the spirit of the book, then the affidavits proffered by the voluminous list of literary critics on both sides of the case are irrelevant. I must say, though, that as a law and literature scholar, it gave me a bit of a thrill to see literary critics fighting it out in the form of legal affidavits. It was a nice blurring of genre lines and very entertaining reading as well, particularly the anti-Dreiser ones, Dreiser ones. I'll give you a little taste of them. Corey Ford, literary critic for Vanity Fair magazine, wrote, "I have just viewed a showing of the picture entitled An American Tragedy and find that the photoplay is infinitely more entertaining and more convincing than the book upon which it was based. I consider it a decided improvement in every way upon Mr. Dreiser's effort, and congratulate Paramount on having turned what I consider a dull and uninteresting novel into a live, interesting, and convincing photoplay. Not only does the character of Clyde Griffiths in particular emerge as thoroughly sympathetic, but I think Paramount has achieved the even more difficult task of making Mr. Dreiser seem sympathetic also." And Charles Brackett, one-time drama critic for The New Yorker. "I was an admirer of An American Tragedy as a book. It seemed to me to humanize a great legend so successfully that the magnificence of that legend survived the retchings and belchings of Mr. Dreiser's style. The picture preserves that legend in its entirety, omitting the retchings and belchings and improving the original by condensation. Mr. Dreiser could learn a good deal from a thorough study of the film." A related aspect of this case that fascinates me is the legal and literary interpretation engaged in by the judge and by Dreiser. The judge construes the terms of the contract quite narrowly, but allows for a generous interpretation of Dreiser's novel. Remember, he said, "Whether the picture substantially presents the book or not depends on your point of view." So multiple interpretations are possible, and the author doesn't get to dictate one correct interpretation. Whereas Dreiser was wildly creative in his interpretation of the contract and of the legal rights of authors more broadly, but exceedingly narrow when it came to literary interpretation, at least where his own work was concerned. It's of course not surprising that a writer would want readers to interpret his text the way that he intended that they should, but it's a bit of an extreme position to say that there's just one correct interpretation that everyone must follow. What about my primary focus, though, returning to the thread of concern for literary reputation that links these three cases? Dreiser is the only one of the three to have lost his case, which would suggest that he failed in his quest to protect what he termed his literary character. I would argue, though, that of the three, Dreiser was perhaps the most successful, or at least the most immediately successful in this. While a victory in court certainly would have been gratifying, I don't think that he expected one. His lawyers had told him that his chances were very slim. And I don't think that a legal win was his ultimate purpose. His purpose was to get his view before the public, and the publicity that the lawsuit generated meant that he was very successful in doing that. These clippings are just from the New York Times, so multiply that coverage across the country of all of the antics in the courtroom. But of course, the quotations from the critics and so on, you can imagine why they would have generated some entertainment. In any event, he couldn't stop Paramount's version of the story from reaching the public, but he could ensure that many members of the public, when sitting and watching that film, would watch it with his contrasting view in mind, or at the very least, they wouldn't presume that he approved of that version, because they would have heard all about the lawsuit. And indeed, although the film opened to good reviews, it quickly sank out of sight, and it's now very difficult to find a copy. I've not managed to find one to watch it. And this is perhaps in large part due to the bad publicity that the lawsuit generated. Now, you might be thinking to yourself, I'm sure I've seen that film. If you're thinking that, you probably saw this one, A Place in the Sun, which was Paramount's second attempt at an adaptation, and they waited till Dreiser was safely dead before they did this one. So there you go. To conclude, I want to circle back to my opening assertion that we can learn something about literature through law and something about law through literature via lawsuits involving writers as litigants. Our tour through these three cases, I think, nicely demonstrates the former point, offering new insight into Poe, Montgomery, and Dreiser, and into the literary cultures of which they were a part. What, though, does our examination of these cases reveal about law, specifically about law as a tool for protecting literary reputation? Perhaps simply that it's an uncertain tool with unpredictable effects. We see, for example, Poe winning his case, but in bringing it, generating publicity that ultimately caused him greater damage than the original libel. And we see Dreiser, in contrast, losing his case, but through the attendant publicity, achieving his goals. If we adopt a longer view, as I did with Montgomery's case, the effects of legal action can appear to be more mysterious and diffuse and complex still. Of course, the chief truth that a long view reveals to us is that a writer's reputation decades on doesn't turn on the outcome of any particular lawsuit, but rather on the quality of their work. Thanks.